Hello, LiveLaw viewers. Welcome to Courts Today. Let us dive into the important legal headlines of the day. The Supreme Court has criticized the tactic of obtaining bail by offering money deposit and later challenging condition as onerous. The Supreme Court has commended Tamil Nadu for using preventive detention against cyber offenders. In the Surat rape case, the Gujarat High Court has granted Narayan Sai temporary bail to meet his father Asaram Bapu on humanitarian ground. A PIL filed in Madhya Pradesh High Court has sought ban on the Jain ritual of fasting unto death for minors. The top court has refused urgent listing for Hany Babu's application in the Bhima Koregaon case. In the PPL copyright issue, the Supreme Court has clarified that third parties are not exempt from paying license fee to PPL because of the stay in Azor's favor. And the Karnataka High Court has asked Bruhant Bengaluru Mahanagar Palike to inform on the mechanism adopted to tackle potholes and maintain good roads. I'm your host Urvashi Chauhan, bringing you the important legal updates of the day, quick, crisp and to the point. Watch till the end, and if you find this update valuable, do not forget to like, share and subscribe because your support keeps us going. The Supreme Court today came down strongly on the growing trend of the accused persons securing bail by voluntarily offering to deposit large sums of money only to later backtrack by calling such conditions excessive or claiming that their lawyers had no authority to make the offer. A bench of Justices K.V. Vishwanathan and N. Koteshwar Singh called out this practice as a misuse of judicial process, stating that courts cannot allow parties to play ducks and tricks with the court as the sanctity of the judicial process must be preserved. The court was hearing a bail plea involving a CGST case where the accused was arrested in March 2025 for alleged tax evasion of 13.7 crores. When the case was before the Madras High Court, the accused counsel claimed the petitioner had already deposited 2.8 crores and was willing to deposit 2.5 more without prejudice to his case. Based on this offer, the High Court granted him bail subject to a deposit of 50 lakhs upfront and 2.5 crores in total. Later, the High Court modified the order and allowed the petitioner to pay the 2.5 crores after release, warning that failure to do so would cancel the bail. The accused then moved the Supreme Court, arguing that the bail conditions were harsh and that the previous counsel had acted without authority. The Supreme Court took serious note of this shift, saying that such voluntary offers during bail hearings were being used to bypass merit-based scrutiny by the courts. It stated that excessive bail is no bail, yes, but calling a voluntary offer onerous later and blaming the lawyer undermines the entire process. Initially, the court had set aside the High Court's orders directing the petitioner to surrender within a week and ordered fresh consideration of his bail on merits. But later, considering personal grounds, including his wife's pregnancy and aged father, the court chose to maintain the earlier payment condition as an interim measure for bail. The bench stressed that courts must remain alert to such tactics that, while personal liberty under Article 21 is vital, respect for judicial integrity cannot be compromised. The Supreme Court has welcomed Tamil Nadu government's use of preventive detention in cybercrime cases. The top court today appreciated Tamil Nadu government's use of preventive detention laws against cybercrime offenders. This was while hearing a plea against such a detention when Justice Sandeep Mehta called it a very welcome approach, noting that normal criminal laws often fail to tackle these offenders effectively. Preventive detention means keeping a person in custody not because they have committed a crime, but to stop them from committing a possible future crime that may threaten public order, safety or national security. The case here before the court involved Abhijit Singh, a resident of New Delhi and native of Punjab, who was arrested on 25th July last year in a cyber fraud case registered in Tamil Nadu's Hany district. The complaint alleged that he cheated a woman of over 84 lakh, with 12 lakh allegedly transferred to an account operated under his company's name, Creative Craft. Investigators said that Singh created multiple fake companies and bank accounts in his and his family members' names to siphon off funds. On 23rd August last year, the district collector issued a preventive detention order under the Tamil Nadu Prevention of Dangerous Activities Act. The detention was confirmed by the advisory board in September and extended for 12 months by the government in November. Singh's father had earlier challenged the detention before the Madras High Court, arguing that the action was illegal, violated constitutional safeguards under Article 22, Clause 5, and lacked urgency as it was based on a single incident. He also said that inadequate time was given to his son to respond to the detention notice. The High Court dismissed the plea, finding no procedural or constitutional flaws in the detention process. The matter then came before the Supreme Court. During the hearing, Singh's counsel reiterated that the alleged fraud was an isolated event and that there were no prior criminal records. He argued that the 12-month detention was excessive and unfair. Justice Mehta, however, pointed out that the duration of preventive detention is a matter of state discretion and cannot be shortened by the court unless the detention itself lacks legal basis. The bench, comprising Justice Mehta and Justice Jo Malya Bagchi, directed the registry to take the state's counter affidavit on record and listed the matter for further hearing on Wednesday, that is, day after tomorrow. Stay tuned. Moving further, the Gujarat High Court has granted 5 days temporary bail to Narayan Sai, son of self-styled godman Asaram Bapu, on humanitarian grounds to allow him to meet his ailing father. Both father and son are convicted in separate rape cases and serving life imprisonment. In its June 20th order, a division bench of Justices Ilesh J. Vora and P.M. Rawal noted that Narayan Sai has been in jail since 2013, and during his previous temporary bail with police surveillance, no untoward incidents were reported. The court observed that due to both being lodged in separate jails, the father and son had not met in person since their arrests. While granting bail, the court also took into account Asaram's serious health condition. However, it strictly barred Sai from meeting any followers or holding group interactions during the bail period. The court made it clear that the relief is granted purely on humanitarian grounds and does not impact the merits of the case. Let me tell you, Narayan Sai was convicted in April 2019 by a Surat Sessions Court for multiple charges including repeated rape, unnatural offences and criminal intimidation based on allegations made by a former Sevika who accused him of sexually assaulting her at his ashram between 2001 and 2005. He has been serving life imprisonment since December 2013. During the hearing, Sai's counsel argued that he never met his father since the arrest and his father's condition was critical. He requested 15 days bail, stating Sai was the only son. The state opposed the plea, citing Sai's past misconduct in jail, forgery of documents during a previous bail plea, and the risk of law and order problems due to the duo's large following. The state also noted that his furlough request had been rejected earlier for similar reasons. After considering all submissions and past conduct, the court allowed a temporary bail for 5 days with strict police surveillance, making it clear that no mass contact would be permitted. The main appeal is scheduled for final hearing on 11th July now. In the next update, a public interest litigation has been filed in the Madhya Pradesh High Court seeking a ban on the Jain ritual of Santhara for children under 18 and persons of unsound mind. Santhara, as followed in Jainism, involves a gradual and voluntary reduction of food and water with the goal of spiritual purification and detachment from the world. The petition comes after the tragic death of a 3-year-old girl in Indore who was allegedly made to undergo Santhara by her family. According to the plea, the child was locked in a room and starved until death, despite being too young to understand the practice or give consent. The petitioner argues that this ritual should be restricted only to consenting adults who understand its implication and should never be imposed on minors or individuals who cannot give informed consent. The PIL has been filed by a social worker who alleged inaction by authorities despite his earlier complaints. The respondents in the case include the Union of India, the Madhya Pradesh government, NHRC, and top district officials in Indore. The plea also alleges that soon after the passing away of the minor girl, her parents and the family members approached the Golden Book of World Records and applied for certification of the youngest person to undergo the Santhara process. It claims that thereafter the certificate was issued to the parents of the minor deceased girl. Thus, the petition has prayed to issue direction to the respondents to ban the practice of Santhara for children aged below 18 years and persons of unsound mind, and to take action against such persons who initiate the ritual on them. The High Court bench of Justice Vivek Rusia and Justice Binod Kumar Dwivedi has asked that the parents of the deceased in this case be added as respondents and directed the petitioner to explain the basis of the certificate allegedly issued to the parents by the Golden Book of World Records. The top court today refused to urgently hear a plea filed by former Delhi University professor Hany Babu, who is an accused in the Bhima Koregaon case. He had actually sought a clarification that he was free to approach the Bombay High Court for bail. For those of you who might not know, Hany Babu was arrested by the NIA in July 2020 under the UAPA for alleged links to Maoist activities in the Bhima Koregaon case. In September 2022, the Bombay High Court denied him bail. He later filed an SLP before the Supreme Court. But last year in May, he withdrew that SLP, intending to approach the Bombay High Court again, citing a change in circumstances. However, last month, the Bombay High Court observed that the Supreme Court's order allowing Babu to withdraw his bail plea did not explicitly state that he had the liberty to reapproach the High Court. Hence, the High Court asked him to get a clarification from the top court. Following this observation of the High Court, Babu moved the application in the Supreme Court seeking such clarification. Well, today his counsel requested urgent listing of this application. But the bench of Justices K.V. Vishwanathan and Justice N.K. Singh declined urgent hearing during the partial working days, pointing out that the order requiring clarification was passed on 2nd May and the Supreme Court was open until 23rd May. Justice Vishwanathan questioned the delay, and Babu's counsel explained the delay that was due to time taken in obtaining certified copies. But the court responded that in cases of real urgency, even uncertified copies are accepted. The top court has directed that the matter would be listed only after the court reopens following the vacation. Moving further, the top court has clarified its interim stay order from 21st April this year in the copyright dispute between Phonographic Performance Limited, that is PPL, and Asaram Hospitality, that it applies only to the parties involved in the case and not to third parties. Let me give you a brief background here. The original dispute began when PPL filed a copyright infringement suit against Asaram Hospitality, which runs restaurant chains like Mama Goto and Dhaba, for allegedly playing PPL's music without a proper license. On 3rd March this year, a single judge of the Delhi High Court passed an interim injunction restraining Asaram from using PPL's songs, noting that a prima facie case of infringement had been made out. Asaram appealed this decision and the division bench modified the order by allowing Asaram to continue playing the music but directed it to pay license fees as per the tariff of Recorded Music Performance Limited or RMPL, even though PPL is not a member of RMPL. PPL challenged this modified direction before the Supreme Court, which on 21st April this year stayed the order requiring Asaram to pay according to RMPL's tariff. However, the top court did not reinstate the complete ban on playing the music. Following this stay, PPL noticed that several third parties had started relying on the Supreme Court's stay to avoid paying license fees for using PPL's sound recordings, which prompted it to seek the clarification. A bench of Justice Ujjal Bhuya and Justice Manmohan of the Supreme Court heard the interlocutory application and clarified that the 21st April order is binding only on the parties to the case, namely PPL and Asaram Hospitality, and cannot be interpreted as applying to other entities. With this, the court made it clear that third parties cannot use the stay order as an excuse to avoid paying for copyrighted music. And lastly, the Karnataka High Court today directed the Bruhat Bengaluru Mahanagar Palike to file a detailed affidavit explaining the steps it takes each year to fix potholes and maintain roads in good condition for both pedestrians and vehicles. A division bench comprising Acting Chief Justice V.M. Kameshwar Rao and Justice C.M. Joshi passed the order while hearing a 2015 public interest litigation filed by a citizen seeking court directions for pothole repairs and removal of encroachments on stormwater drains in Bengaluru. Back in September 2024, the court had already directed the BBMP to provide information on the mechanism it uses regularly to deal with poor road conditions and potholes, as well as the steps taken during that year's monsoon season. It had also asked the BBMP to clarify whether there was any policy or process for compensating people injured in accidents caused by potholes. During the latest hearing, the petitioner's counsel argued that despite the case being monitored for nearly a decade, only small improvements have been seen. The court asked whether a fresh affidavit had been filed identifying the city's most critical areas. The counsel replied that all areas were critical but agreed to submit the affidavit. The petitioner further submitted that although BBMP claims to follow scientific road repair methods on paper, the ground reality is different. BBMP's counsel requested 1 week's time to file the required compliance affidavit, which the court granted. The matter remains under active monitoring by the High Court as the condition of Bengaluru's roads continue to raise concerns over public safety and civic accountability.